This will be our last screenshot video for the introductory course. This is the last 2 weeks that we're doing. I believe it's weeks 13 to 14. I have on the screen a general outline of concepts in property. Don't worry about the posting numbers. These were put for past semesters, and I'm not guaranteeing that they line up. But the deal is, this is what we're supposed to be looking at for this screenshot video. Let me just take a minute, and I put a video up last week sort of setting forth where we're going. So today is Sunday, April 18th, as I'm recording this. Sometime early the week of the 25th, I'll have the final exam up. It will be 40 points worth of evaluation. I also have up a extra credit project that you can do, but it's purely voluntary, if I can say that. That's can bring you up to 10 points. No guarantee you would get 10, but certainly if your grade is lower than you'd like, it's a way to get extra points for the course. I have quiz 4 tomorrow, the 19th of April is the last date for late submissions, so I'll be grading those sometime this week and making some kind of response. The last topic we're talking about is just some general concepts in the law of property. In the real estate practice course, you'll be talking about what we call real property and how real estate transactions work. In the course that has estates in them, and in the business structures course, you'll be talking about personal property in the form of assets of an estate, in the form of ownership interests in businesses and the like. In the domestic relations part of the course, you'll be talking about something known as marital property, which is how, in the event of a divorce, or for purposes of a prenuptial agreement, spouses divide up property. I don't teach any of those courses, so this is what I have to say in a very general way about just some general outline that hopefully will put you on a platform to understand the other more specific rules better. In any event, we could start out can be divided into 2 general categories: real property, land and buildings, and personal property. And for our purposes, we could say all other forms of property. In the real estate practice course, you'll be talking about real property. One concept contained within real property is the idea of a fixture. And a fixture begins its life, let's say, as a chandelier being sold at Home Depot, or maybe some fancier place. Person buys it, brings it home, and at least in my case, with the assistance of an electrician, puts the chandelier in the dining room ceiling. At that point, the chandelier has become part of the real property because it's a fixture. So if I were to sell you my house, I'm selling you all of the real property, and it would include the chandelier because it's part now of the real property. The other type of property, which would be everything other than land and buildings, would be personal property. And if we take a look at personal property, we can see that it can be divided into 2 categories. We have tangible personal property, and we have intangible personal property. Tangible personal property would be property that has a physical dimension. For example, if you're looking at a desktop or a laptop, your computer monitor, your smartphone, if that's what you're looking at. But we also have this category of personal property known as intangible personal property. And it is personal property that simply doesn't have a physical dimension. So if we look in this next paragraph, we can see that people own things that cannot be seen because they do not have a physical dimension. If you loan me $20, you have the legal right to receive the loan under the conditions you and I attached to the transaction. The loan might be evidenced by some kind of document, but the right that you own, which is to receive the loan, has no physical dimension. Even if I sneak into your house and tear up the IOU, you still have the legal right to collect the $20 from me. And if we think about it, we can see that intangible personal property consists of legal rights. In addition to a debt, we could identify trademarks, copyrights, and ownership in a corporation. So if we focused on ownership in a corporation, I'm guessing you'll learn in the business structures course that ownership in a corporation typically consists of 3 rights: the right to participate in management by voting for the board of directors, the right to receive corporate profit in the form of dividends, and the right to receive a proportionate share of corporate property if the corporation dissolves. Again, those rights will be evidenced by a stock or share certificate, but the certificate itself is evidence of ownership and is not the ownership. So we've looked at the 2 categories of property, real property and personal property. In the area of personal property, we've divided that property into tangible and intangible property. Now let's take a look at a new category, which is co-ownership of property. And when we talk about co-ownership of property, we're just making a very basic observation that property can be owned by more than one person or entity. By the way, when I'm referring to entity, I'm thinking of corporations or limited liability companies, estates, because an estate is not a person, but of course it's what a dead person leaves behind. It could be that we're talking about a municipality, City of Buffalo owns property, a school district owns property, etc. But what we just have to appreciate is that property can be owned by more than one person. And I'm going to use the example of real property because it's a example that some of us at least have had some experiences with. And so spouses, for example, can purchase a house together. Maybe you and 2 of your siblings might purchase a cottage on a lake to use for family vacations. In the first example, we've got 2 people owning the real property. And in the second example, we've got 3 people owning the real property. Now, here's a significant question that needs an answer. And that is, when we have co-ownership, what happens when one of the owner dies? Again, when we have co-ownership, what happens when one of the owners dies? And a lawyer involved in doing these transactions, of course, has to think ahead, and she or he has to say to the folks who are going to be owning property together, what is their answer to this question. For example, spouses, not always, but usually are going to want to own the property so that if one of them dies, well, one of them is going to die, but when one of them dies and if they're still owning that property together, that the property automatically goes to the surviving spouse. However, maybe you and 2 of your siblings, what you might want to think of doing, it's entirely up to you folks, but when one of you die, if you all 3 still own the property together, that person's share doesn't go to the other 2, as, for example, the spouse's, the share of the deceased spouse went to the other spouse, but maybe that the share goes to the estate of the deceased sibling. And so what we would need to do is understand what the rules are regarding co-ownership in the event of death. And the law, I think, loves to throw confusion into terminology. And so the law addresses co-ownership by looking at the concept known as tenancy, T-E-N-A-N-C-Y. So most of us, our earliest experience in dealing with real property is that we rent an apartment or a house somewhere, and we're the tenant and the owner is the landlord. But tenancy here is used as a way to describe co-ownership. So we have different types of tenancy for co-ownership of property, and the significant difference to answer our question about what happens when one of the owners dies is this a tenancy in common, or is it a joint tenancy with a right of survivorship? If it's a tenancy in common, when one of the co-owners dies, the interest of that deceased co-owner goes to their estate, and that maybe is what you would want to do if you buy that cottage with two of your siblings. So if A, B, and C are tenants in common and A dies, A's interest in the co-owned property goes to A's estate. In a joint tenancy with a right of survivorship, the interest of the deceased co-owner goes to the other's joint tenants. Spouses have a joint tenancy with a right of survivorship, but it's also known by tenancy by the entirety. And as I point out, a tenancy by the entirety is really a joint tenancy regarding the spouses. The different labels deal with creditors' rights that we're not going to be concerned about. So that really is what I want to say about the co-ownership, which is the last topic I have in the outline. I did mention marital property. It's not on the outline. Let me just say a couple of words about it. Again, it refers, and I'm just confining my comments to New York State, and when spouses get divorced, if they do, what has to happen at that point is the property that they own has to be put into a category, and that is it owned by one spouse or the other spouse, or is it marital property? Now, the deal with marital property is that it could mean that a piece of property is owned by only one spouse, but under the rules of marital property, some or all of that value of the property is marital property. So a quick personal example of a person owns a house before marriage. There's a marriage, let's say of 15 years. Over the course of the marriage, the house is increased in value. It may well be that even though the property is only owned by the one spouse, in the event of a divorce, the increase in value will be treated as marital property. And the deal, as you'll learn in the domestic relations course with marital property, is that it must be equitably divided between the spouses. And so in New York, all of those rules about marital property are summed up under the idea or concept of equitable distribution. Okay, that'll conclude this screenshot video.